if we're going to be a country where the enforcement of matters of fraud, we're talking about here, real financial fraud, some cases multi-billion pound, maybe even multi-billion pound frauds. If the participants can't rely on the law, then they're unlikely to think that the UK is a good place to do business.
Welcome to the IEA Podcast. My name is Matthew Lesh and I'm the Director of Public Policy and Communications here at the IEA. Each week this podcast asks a tantalising policy question to a top political and economic thinker. This week's question: what's wrong with the Serious Fraud Office? The SFO has had several controversies in recent history. Just earlier this month, the G4S case was dropped as a result of a failure to disclose evidence. That was a case against some senior G4S executives. Now, according to a new IEA report, Fraud Focus, the organisation has long suffered from cultural and institutional failings. To discuss this topic, I'm excited to be joined by the report author, Dr. James Forder, who's the Academic and Research Director here at the IEA, as well as a tutor at Balliol College, Oxford. James, let's start off with the real basics here, because I presume most people have never actually heard of the SFO. What is the SFO?
The SFO is a specialist agency for the investigation and prosecution of, as the legislation says, serious and complex fraud. It's for the big cases and the complicated cases, and some of the cases are very complicated indeed. It has special powers in investigation, and it has in Britain, the unusual feature of combining investigation and prosecution. So it's responsible for both. It will investigate and, depending on what it thinks of the investigation, obviously prosecute as well. So that's all under the one roof rather than having, as it were, the police investigating in the Crown Prosecution Service.
And what's the underlying logic of why this has been designed in this format? Because as you said, traditionally the police would investigate, like the Crown Prosecution Service would prosecute any, I suppose, most other crimes. Why has the SFO got this special model?
I think because of the complexity. It dates from the 1980s. There was an inquiry into this. It was felt that before then, prosecution of serious fraud had been unsatisfactory, and with the thought, of course, there's a whole report on this, but the thought would be that the complexities of the cases are much more easily handled by having a single team, potentially, a single individual in the lead, potentially, handling the case all the way through, so that we don't end up with the prosecutors wishing that some detailed point had been investigated and the investigators hadn't thought of investigating it, and so the case fails for that kind of reason. Or alternatively, the investigators investigating things that are of no use to the prosecutor. Just because of the complexity of it, it would be hard to, if the police are taking fingerprints to see whether somebody broke into a house, well, they know what to do. They don't need to be the same organisation as the prosecutor for that. And
what is the importance of the SFO and prosecuting financial crime?
Well, there's a couple of ways of looking at that. One thing would be the enforcement of law and order. That's always important. In a country that aspires to remain a global financial centre, we really do have to be able to count on the rules being followed. People have got to understand what the rules are, but then if we're going to be a country where the enforcement of matters of fraud, we're talking about here, real financial fraud, some cases multi-billion pound, maybe even multi-billion pound frauds, if the participants can't rely on the law, then they're unlikely to think that the UK is a good place to do business. But then there's a further thought as well, which is, of course, these are big money frauds by rich people if they're happening, and it's not all right to say to take a slack attitude to the enforcement of the law on rich people, and some of these are very, very rich people with very, very big frauds or alleged frauds. Of course, it's important to apply the law properly there and make the prosecution stick.
So I suppose there's that underlying moral case about the rule of law and ensuring that people are prosecuted for their crimes, and then there's the broader kind of if you look at the political economy or institutional design, that you want to have a system where people know that if they invest their money in the UK, if someone does commit a fraud against them, that it'll be properly tackled. Now, I suppose that's where the problem has often been with the SFO, which is it's managed to embroil itself in quite a number of failures. And your report, it's almost, I think, was described by the Times as a charge sheet of, in its own right, of going through the history of the failures of the SFO. I mean, what stands out to you from your research?
Well, I did not know about this, all these problems before I started doing the research, and I think there were two legs to it. One leg is that the law and the rules of prosecution are indeed very complicated. It's not only the cases that are complicated, it's the law that's complicated as well. And I can see that does make things difficult for an investigator and a prosecutor. And I think there's various aspects of the law need to be looked into there. Secondly, though, complex and difficult as it is, the Serious Fraud Office was created precisely for the purpose of acquiring expertise in handling these complexities. And it does seem as if again and again they make related mistakes. We certainly wouldn't say they make the same mistake, but related mistakes. You mentioned disclosure earlier on. There's much more to be said about that. Again and again they're making mistakes there. But there's also an aspect, seemingly, and one can hardly believe one's eyes when one sees the sometimes trivial improprieties that get in the newspapers, sometimes very substantial ones, but the unacceptable behaviour of some of the officers in the SFO has created quite a catalogue itself, and I must think that something is wrong culturally in an organisation like that. So I said there were two things, perhaps there were three. There's the complexity of the law, there's the mistakes that the SFO has made, and there's the behaviour of the individuals on a recurring and mysteriously recurring basis.
Yeah, it seems like what happens here effectively is the SFO will make a big deal about trying to investigate a particular issue. I suppose very legitimately there's been some allegation of fraud. It'll then in some way, in a multitude of cases, make quite fundamental errors as investigated, as prosecutors, and then after spending millions of taxpayer pounds investigating some case, there have been these cases again and again, the G4S one being the most recent one, where they've been forced to drop the case. So it's very much justice not done properly in two respects. One, if these people are innocent, then the SFO has been investigating them for many years. This has been held over them effectively for such a long period of time. And that's unfair to people who are the defendants. Absolutely. But also to the public, if there was a genuine case against them, they've screwed up the case that they were meant to do and they've wasted the taxpayer money in the process.
And the fraud has gone unpunished in that case. Yes, absolutely. So the case, to illustrate a little more firmly, the problem of disclosure, which has again and again caused a problem for the SFO. The point is that very commonly the prosecutor will be in possession of evidence which is useful to the defence, and there's a general rule that such evidence must be disclosed to the defence. The defence doesn't have the investigatory powers that the prosecutor has. The prosecutor is not allowed to, as a general legal principle, the prosecutor is not allowed to investigate the matter and then, as it were, present all the evidence seeming to point to guilt and conceal
surprise,
yeah, they've got to be open about the whole collection of evidence they have. So they must disclose to the defence the materials which are potentially relevant to the defence. Now, that's certainly difficult because there are some of these cases, millions of documents and electronic resources, and they all have to be one way or another checked to see whether they are disclosable. They should be disclosed. But there you are, that's one part of the expertise the SFO is supposed to have. When they disclose improperly, incorrectly, then later on it turns up that something or other should have been disclosed, then either the case fails, the case is still ongoing and it fails right there because somehow it's gone wrong at an earlier stage, or they end up in appeal and somebody says, well, if I'd known that, then I'd have had a different and better defence, and the case gets overturned on appeal. And exactly as you say, there's a catastrophes all round, some innocent people being subject to investigation and trial which might go on for years, some guilty people, one supposes, but doesn't know, of course, some guilty people presumably not being convicted because of a failure of disclosure, which has created sufficient doubt for the case not to go ahead or to be overturned, conviction to be overturned. And millions of pounds wasted, yes, as we say, and the law not enforced.
So those are the cases where I suppose it's more serious. But in other cases that you discuss in the report, it comes off a little bit more of like a soap opera. You've got the case with the former Liberal leader, Sir David Steele, who, as I think was meant to be an April Fool's joke, they forged a letter.
Apparently so, yes. So the case is nothing whatever to do with Sir David himself. He happened to have made public comments on the handling of the case, and the appearance is that the Serious Fraud Office found it rather difficult. And so they managed to turn up and present one of the barristers with a letter purporting to be from Sir David, saying that he was going to show up on behalf of one of the participants in the trial. There was apparently nothing in this. It was just it
was almost a case of serious fraud, you might even say.
It's unserious fraud. And the explanation given was that it was an April Fool joke. Well, it's not all right for the public prosecutors to be playing April Fool jokes during court proceedings on leading politicians.
Yes.
That isn't okay. It's not funny either.
And another case, maybe a little bit more serious as well, was when the SFO accused a judge of collusion.
Well, apparently so. This is a complicated matter. There was a suggestion that a judge was going to be investigated, supposedly for more or less being in cahoots with an accused person who was said to be wanting to try to escape the country. And some of the facts about this are very odd. The judge was most put out about it and ended up... we do know he ended up getting an apology from the Serious Fraud Office for this, so there was something going on there. Yes, quite so. It's an extraordinary allegation and, of course, crushing, if there'd been anything in it, which, of course, there wasn't, if there'd been anything in it, the crushing blow against the English judicial system generally. To have a judge, had it turned out, of course it didn't, but had it turned out the judge was doing this, so the accusation of it needs to be very carefully considered. But apparently the SFO managed to lose the plot sufficiently.
And in an ironic twist, in a separate case, the SFO was actually in collusion with the defence attorney.
This
defence lawyer, I should say.
This is an astonishing case. Yes, the chief lawyer for the defence was apparently supplying information to the prosecutor. Now, of course, that's a breach of professional conduct rules by the lawyer. That part's obvious, but it's also not acceptable behaviour by the prosecutor. And the prosecutor, it's easy to perhaps, from outside the judicial system, form the impression that the prosecutor's job is to get a conviction. Well, it's not. The prosecutor is an agent of the public seeking to bring about just outcomes, and there are rules about how that can be done. And the defence lawyer's job is to defend the client. Well, the prosecutor, therefore, acting for the public, cannot be colluding with the defence lawyers trying to do down his own client.
Do you ever feel sometimes just reading through all this, you could almost imagine a TV show, the SFO was some weird kind of soap opera like The Office, or maybe even a little bit like Veep or something. It just seems so ridiculous that this supposedly august organisation has got put up with so much.
How they could have thought how anybody in the organisation could have thought that was acceptable behaviour. It's just incomprehensible.
Yeah.
It's astonishing.
So on to, I suppose, back to kind of the more kind of serious questions in terms of the way the SO operates. And there's this quite heavy use you talk about of deferred prosecution agreements.
Right.
So how do they operate, and what are some of the issues with that?
Well, the principle is that when an organisation, a company presumably is under investigation for a fraud, it can enter into an agreement with the Serious Fraud Office to change its behaviour and set up checks and all the rest of it, and very probably pay a fine, pay an amount. And by this, and the SFO for its part doesn't prosecute. It stops the investigation and doesn't prosecute. So lawyers won't like me saying this, but never mind, it's of the family of a plea bargain. It's like saying, well, all right, we'll change our behaviour if you don't prosecute us. It's not a plea bargain because in the rules there need be no admission of culpability by the company. So they are, as it were, morally in the clear. They're not admitting to anything being done, but they may be paying a large amount of money. Now, this is a problematic. One can see the motive for it because it saves on the expenses and difficulties of prosecution. It saves on the uncertainties of prosecution as well. It gets quick resolution. But it's very problematic because it doesn't properly achieve justice. It threatens a world where paying these sorts of amounts, it becomes like a cost of business. These matters are legally very complex, and I can well imagine a large company not being quite sure whether it may be in breach of a regulation somewhere. The Serious Fraud Office comes along and starts investigating. Now you say, well, what's the best thing to do here? Fight this all the way, or accept the fact that we might have done something wrong. We might not even be guilty in their minds. Now, meanwhile, at the other end, I'm very concerned that the Serious Fraud Office has had such difficulty bringing successful prosecutions for these various reasons that the temptation on it to look to the deferred prosecution agreement as a preferred outcome must be quite strong. And then we're in a very nasty situation where both sides would rather settle for an amount of money, and neither of them is powerfully motivated to secure justice. And that's what I mean by becoming a cost of business.
Yeah.
It's a very undesirable outcome. I think there's more to it because I'm very uneasy about the way that the Serious Fraud Office has started reporting the amounts raised, which of course have become public funds, the amounts from the companies entering into deferred prosecution agreements, presenting these amounts raised as it were in themselves a success, but they're a success for the Exchequer. They're not a success for the justice system.
Indeed, and in fact, I think in response to your report, the SFO basically said, we've dealt with all these issues and we've raised X amount of money, but that doesn't deal with the underlying question about the rule of law. I'm wondering if we just come to, I suppose, what you think is driving this, and therefore what might be some of the remedies to what the SFO has been doing and all the problems that you've identified.
Right. Well, the rules of disclosure certainly very complicated, and it's a lawyer's problem to understand what could be done to simplify that. It occurred to me that it may be an opening for artificial intelligence. Clearly AI devices could be used in any case, but the question is whether we'd like a legal recognition that on some terms to be determined, documents that have been checked by approved artificial intelligence stay checked. There isn't an appeal lying from failure to disclose a document that was checked in the proper way. Now, that's quite a dramatic step because there could be exculpatory documents that escape the AI check, but on the other hand, this could, we're not serving justice as we are, so we have a dilemma here. So that would be a possibility, but in any case, serious attention to the matter of defining disclosability and making it practical operation to get through millions and millions of documents to decide what to disclose. That would be one. There's another problem about the exact definition of culpability in corporate prosecutions. And there's the law here is old, and it requires, I speak a bit roughly, of course, because the law's technical, but it requires the prosecutors to identify an individual who knew what they were doing, they knew they were doing something that shouldn't be done, and was properly in control of the doing of it. And In a large corporation, very possibly isn't such a person. The people who know what they're doing may be at one level of management, and the people actually doing the deed are other people. So there's no individual who's properly identified in this kind of way. Now, there's a sort of legal dilemma there as to in what sense the corporation is guilty of something if there's no individual in it who is guilty of anything. But we recognise that elsewhere in the Bribery Act. The companies have an obligation to prevent bribery occurring. So there's an offence of failure to prevent. Now, it seems to me that a failure to prevent rule in relation to fraud is probably much more enforceable through the kinds of processes we can reasonably have than as an identification on these rather technical rules of individuals. So I think that's, again, of course, that's a matter of deep law and needs a serious investigation.
Institutional and legal changes,
Yes. And the third question that comes up, or perhaps it's two related questions, is about whether the complexity of the trials really means that we have to reconsider trial by jury. The trials are very complicated. It's not altogether reasonable to think that a typical jury certainly will fully understand it. It plainly is the case that the traditional reason, or part of the traditional reason, that the jury bring common sense to the ordinary citizens' common sense to a matter of determining guilt. Well, common sense doesn't have much role in these cases, so that rule is that presumption is, I think, very weak. There are other considerations, such as that if there is to be a jury, then the case almost surely will have to go very slowly, because insofar as the jury can be made to understand can be brought to understand it takes a long time to do it. So the alternative would be, we could have judge-determined cases, of course, but we could also have expert panels, like a tribunal system, where there's a panel which is separate from the judge, so the judge is still running the case, there's still a prosecutor and a defender, and in place of the jury, there's a panel, but an expert panel would certainly allow the cases to go faster, and would probably get outcomes that conform closely to the law. And there's another thought, actually, which is that one tends to think of the jury system as being something that accused people welcome. But it's not so clear that that's true, because in some of these cases, an individual who's been accused of a serious fraud has been all over the newspapers. They've been held up to public vilification for what they've supposedly done. And they might think they'd rather have an expert panel than newspaper reading jury. So they might secure justice better that way, to have people practiced in shutting out of their minds what's been said.
So I suppose what you've just listed would deal with some of the, I suppose, more practical issues of doing the prosecuting. But at another level, and I think you discussed this, it seems the SFO has some deeper kind of cultural issues where it's making these, I suppose, laughable errors or quite clear unprofessional behaviour. Now, some have said that the SFO perhaps should be abolished and its powers reallocated in some way. Are you sympathetic at all to those arguments?
Yes, I am. I think the bad behaviour, there have been some dramatic cases, as we discussed, of bad behaviour, and some pretty trivial but worrying ones. But there have also been a number of reports of poor management, and the recurring matter of disclosure hasn't been effectively handled. They have internal guidelines on disclosure, but then these things are criticised by the inspectors. And so there appears to be a widespread management problem there. There have been reports on it which have described a culture to ignore the rules, for example. So it's far from there's been an April Fool joke played on a politician, and this has been going on now for decades. And one does have to think that maybe instead of appointing new managers and trying to clean up, it would be better to simply shut it down. disperse the staff, start again, set up a new organisation, to do the same thing or possibly reorganise the way it's done, with the question of whether the prosecutorial and investigative functions should be combined might arise. I suspect probably they should be kept together, and that makes it fit slightly poorly with most of the rest of there are other parts of the system that work like that, but it makes it fit slightly poorly. So it takes some institutional design, but the idea that after all these poor outcomes and adverse reports and doubts now emerging about the appropriateness of the use of deferred prosecution agreements and the plain failings of propriety, maybe just the practical thing is to start again. So I do have sympathy with that, but again, it's all, there's many aspects to it, and it takes proper expertise to assess the options.
Well, indeed, James, thank you so much for joining the IEA podcast. If you'd like to learn more about the Serious Fraud Office, you can read James's report on the IEA website. It'll also be in the notes for this episode. If you are enjoying the IEA content, please do subscribe on YouTube or to this podcast feed on your chosen podcast provider.
Well, if you enjoyed that conversation, why not watch one of these other videos? And while you're here, remember to hit the subscribe button and the notification bell. That way, you'll never miss out on a single IEA broadcast.